Welcome to another episode of Outer Temple Chambers Travel Talks. Today's focus is on personal injury damages in the Netherlands, Spain and France. And I am very pleased once again to be joined by Gerben Janssen, Anna Romero and Thomas Ricard. Now, damages is a huge topic and particularly complicated. So today we're just going to be focusing in on non-pecuniary damages, or as is often termed in English law, general damages. So just to start off with, Thomas, if I could start off with you. I'm assuming that the general principle under French law is to put the victim of an injury back in the position that they were if the tort hadn't happened. But practically speaking, what's the approach under French law to general damages?
Thanks, Ian. As you explained, the principle is simple: restitutio in integrum, put back the victim in the state where he would be without the occurrence of the harmful events. But in practice, it's obviously much more complex. The French, with the principle of full compensation, would typically use a list of heads of loss called the Dantillac, which is not mandatory, but widely used. This list provides a sort of structure to analyze each head of loss. And the key principle that we use is called the consolidation date, which is the moment where the claimant's condition has stabilized. Doesn't mean that it cannot improve, it means that it can't get worse. This date, sometimes it happens that in a rather fictive way, we say it's the trial date, sets and help you set the list of general damage. So that's how we proceed with this grid, with the help of experts, which I think we're going to talk about later, and Anna and Gerben will mention that. But that's our starting point, is to fix this consolidation date, this stabilization, which is a medical view, and then proceed.
And that stabilization consolidation date, Thomas, is that determined by lawyers or is that determined by medical experts?
It is ultimately determined by the courts with the help of medical experts. Obviously, it's not for lawyers to do that. And some lawyer would sometimes try, and it's quite risky, particularly with young victims, where you can't really predict how a damage, for example, a broken leg, will impact their life when they grow up. And that's a rather important criteria to set. Ultimately, again, it is for the court to determine which date to retain. They would help medical advice, see how the person's condition may evolve. And the second point, which is often the case with psychiatric damage, is that they can appear a few months, a few years after the accident. So it's quite important to make sure you've got the right medical and legal experts around you, because that's a rather touchy subject in France. You remember in our last session, we mentioned the time limitation, which are 10 years, and which explain also why we are rather careful in this assessment.
Anna, what's the situation in Spain? You have the baremo system, don't you? Is that mandatory across all personal injury claims?
Well, the situation in Spain, well, first of all, thank you, Ian, for having us back here. It's a pleasure to join you and the other colleagues. And the situation in Spain is rather similar to the one that Thomas was portraying in France in terms of the restitutio in integrum. It's a principle that guides the whole system. But then how it applies in reality stays quite far from that principle because of that baremo that you are mentioning, Ian. The baremo is a tool, is a legal tool which is mandatory for victims of road traffic accidents to assess damages arising from road traffic accidents, but it's also used as a guide outside road traffic accidents. So for the baremo, it's true that we have from January 2000 been a huge development in terms of approaching the amounts under the baremo to the reality of society, and there has been a considerable increase in the figures in the baremo, but still there are still caps, there's still limits to the amounts that you can claim under the baremo. So the principle of full restitution is still not achievable under the baremo. That's why for example, in claims, personal injury claims outside road traffic accidents, even though it is a guidance that courts use, because there is nothing else to guide them as to how to assess damages, we can go beyond what the baremo establishes. And I will explain later on how we can achieve this. But the fact that the baremo, the current regulation applicable from January 2016, it's quite well structured in terms of what are pecuniary and non-pecuniary damages, allow us to work on the pecuniary damages to approach this to the reality of the victim. So even in road traffic accidents, this baremo can also be used in a way that for foreign victims, for example, British, UK victims that have accidents in Spain, we can use the principles of the baremo to say that the figures that would come out from strictly applying the baremo would only reflect the reality of Spanish victims with an economical and social reality, which is quite different from the one that the UK victims have. So we try to work under the rules, because the baremo is compulsory at the end of the day, but with the principles that the baremo offers us to apply them to the context in which a foreign victim lives and suffers from the injuries.
So it sounds as if there's a system of quite rigid rules that might apply specifically for a Spanish victim litigating in Spain, but there might be a little bit more flexibility and nuance when we're looking at, for example, somebody who's suffering those injuries abroad, whether or not they be British or from wherever else in the world. Herben.
It is a complex exercise, because at the end of the day we are, putting a norm that, as you said, is worked for a Spanish victim. We need to bring it to a foreign context and with a different circumstances for that victim. But I think it's worth doing in very many cases, because we need to approach that principle of full reparation as close as possibly we can.
Thank you. Herben, what's the overall structure in the Netherlands?
Well, it gets a bit boring, and thank you to have us on again. We have the same principle, restitutio ad integrum, but our practical solution, how we work with it, is a bit different, a lot less structured than in France or in Spain. With us, it's quite a gray area, and normally when you look at what the Supreme Court has said about what you have to look for when estimating the amount of general damages, which is they look at all the circumstances of a particular case, and more specifically, a judge should look at the injuries and the consequences of the injuries on a victim's life, and the judge has to pay attention to case law in similar cases. But we don't have a specific guideline with points or a baremo or anything. So for us, it's always a gray area, to be honest. And you can look at case law, and we also, and we are thankful for the other European countries for that. We can look at how general damages are awarded in other countries, but we are always lacking behind in the Netherlands. Other countries are a lot higher than our country. So we do have a discussion now that because we are lacking behind, a lot of higher judges have said that because of that discussion, the compensation for general damages should at least be 10% higher. And it is an effort for all the lawyers and the judges to explain more how and why a specific height of general damages is applicable. But it's not to be only be honest, a very scientific area. It's always a bit of a feeling and a gray area with regards to negotiations. But we always look at the injuries and we look at the medical experts. We don't have a consolidation date as, for example, in France. We do ask when there is a medical end stage, when somebody has fully recovered or will not recover further, to a medical expert. What, for example, the points of functional impairment are important to assess the height of the general damages in our country. But it's not required. It's not required, but usually you do it because you have to have something of a guideline. And the points with regards to the functional impairment are also always an important guideline with regards to that. And of course, the impact on somebody's life.
So you said that the courts have given guidance as to what factors which need to be taken into account. Is there any further guidance that would assist with, for example, knowing what a particular type of injury is worth? Say, for example, you've got somebody who has fractured their leg. Is there anything that specifically would say, for this type of injury, you usually get between X and Y thousand euros, for example?
What we look at is case law. We have a bundle of case laws every 2 years, verkeersrecht, traffic law. And in that case law, you can find the amount of general damages given by a judge in a case, for example, with the same kind of injuries. But the problem with those kinds of case laws is that judges always look back, so they're quite conservative. So you don't want to go to court for general damages only. You're better off trying to settle the height of the general damages with the insurer herself than when you ask a judge to only determine the height of the general damages. So that's always an issue here. But that's one of that's only two guidelines we really have: the functional impairment and the verkeersrecht with all the case law explicitly about the injuries and the age and everything. Yes.
I suppose that to an extent is music to an English lawyer's ears, because we often find when speaking to lawyers in Europe about case law, and we're obsessed with case law and precedent under the common law system. So to hear that there's another jurisdiction which has a means of recording the case law which you can refer to, and you can go through that comparing and contrasting process, is actually not too dissimilar to the English law approach, apart from we also have a publication of the Judicial College Guidelines, which gives us, again, wide guidance with regards to how to value a case. So that's issued every 2 years, is it?
Yeah, every 2 years there's a new guideline, a new bundle with all the former all the judges that have decided. But you can also look it up on the internet and find perhaps someone that is favorable to your case. But it's just one of the guidelines. You always try to look at what the impact is on somebody's life, and you try to explain that to an insurer. For example, what if you have scar tissue on a man's leg that's worth less than if it's on a woman's leg? So I don't know whether that's the same as in Spain or in France, but that's considered, well, if a woman, for example, doesn't want to wear skirts anymore because of the scar tissue on her legs, then that is an aspect that will get higher general damages here in the Netherlands, to be honest. So we always have to look at the specifics of the case. Yeah. So
everybody's treated as an individual. Certainly that used to be the case formerly here, that a woman with scarring would get more than a man. It's now not official, but I still think that's the unofficial approach. Just one more thing on the Netherlands before we go back to France and Spain. The 10% increase, is there a time date set on that? And was that determined by the courts, or was that determined by Parliament?
That's determined by a court decision, not the Supreme Court, but one below that. And in that court decision, it's stated explicitly that because of the discussion about that the general damages should be higher in regards to the countries around us, that it should be at least 10% higher. And there is the 10% increase is not really up for discussion anymore. but you can still have a discussion. Oh, you always have a discussion about the height of the general damage, which it should be 10% more than what, and then you still have the discussion. But the 10% increase is not up for discussion anymore. No.
Thank you very much for watching, and we'll be looking at pecuniary damages soon. Thank you very much.